Hello and welcome viewers. A very good evening to each and every one of you. My name is Priyanka S. Mathur, Vice President, Supreme Court Women Lawyers Association, and I'm absolutely delighted to be your host this evening. The topic for today's webinar is Law and Life After Triple Talaq, a reality check. And the keynote speaker for the occasion is Ms. Madhavi Goradia Divan, who is not only an additional Solicitor General, Supreme Court of India, but also a source of inspiration and motivation to many young lady lawyers at bar. For this discussion, there would not have been a more appropriate person than her to embellish, to enlighten, and to enrich our valued participants on that topic, sharing her expert opinion views. A very heartwarming welcome and special thanks to her to have kindly consented and agreeing to grace the occasion. Now, moving straight to the webinar topic, let me give you a quick overview of today's session. We have guest introduction by General Secretary SCWLA Prerna Kumari, a formal welcome speech by President SCWLA Senior Advocate Mahalakshmi Pavani Ma'am. Introducing the topic of today's webinar is our executive member, SCWLA, Mrs. Mahi Ravish Rain, then keynote speech by our honored guest, Madhavi Divanji, followed by question and answer sessions taken up by Vice President SCWLA Bhakti and vote of thanks proposed by Assistant Secretary SCWLA Mansa Singh. Dear participants, object behind organizing such webinars is to bring our lawyers community together, interact, learn, and flourish. Remember, viewers, you are precious to us, and we would love to hear from you. So please be ready with your questions related to today's webinar. And this is to note, your feedback is equally important for us to improve further. So once again, welcome everyone, and thank you for joining us today. Over to Prerna for her guest introduction.
Thanks, Priyanka. A very good evening to each and everyone who is watching our webinar. I welcome you all. It's a great pleasure to inform you all that our last webinar was a great success, and that because of your support and good wishes. And once again, with all new gel, we are here with new subject, which is so sensitive in nature that even Supreme Court dealt it with utmost patience and precaution. The council, who was entrusted with the task of framing the government of India's response to the petitions by Muslim women challenging the practice of triple talaq, was none other than our main speaker of today, Ms. Madhavi Divanji, Senior Advocate, Supreme Court of India. It's our privilege and honor to have Madhavi Divanji among us to discuss today's topic, Law and Life After Triple Talaq, a reality check. I thank ma'am wholeheartedly for accepting our invitation and taking out some time from her hectic schedule. To introduce ma'am, I don't know from where to start. She's multi-talented. She is not only a dynamic advocate, but also an excellent writer, an expert orator, and much more. I'm glad to inform you that Ms. Divan has been reappointed as Additional Solicitor General of India. Last term also, she was holding the same position. Many congratulations to you, ma'am. She was designated a senior advocate by the Supreme Court of India, where she has practiced since 2007 on a range of subjects which include constitutional law, media law, commercial law, and environment law. She holds a degree in law from Cambridge University, where she was a Cambridge Commonwealth Scholar. She has represented the Government of India in several landmark constitutional cases in the Supreme Court, which include the Triple Talaq case, the NJAC case on judges' appointments, and the challenges to the Insolvency and Bankruptcy Code. Madhavi ma'am is the author of a book on media law titled Facet of Media Law. The book is widely used by the practitioners and media persons. and is a recommended textbook in several law schools across India. She contributed to the seminal publication Courts of India, Past to Present, published by the Supreme Court of India in 2016. Madhavi ma'am regularly writes for leading law journals and newspapers. She is the editor of the Indian Advocate, a journal published by the Bar Association of India. She has been a guest lecturer at several law colleges across India and has participated in several law conferences as a speaker on media law and gender rights. Madhavi ma'am was awarded the Women Lawyer of the Year Award 2017-18 conferred by Legal Era at Mumbai, March 2018. She was also awarded Excellence Award 2018, honoring distinguished service and contribution to media and constitution laws, CXO and DC Leadership Summit, New Delhi. She was also awarded Women Lawyer of the Year 2019 by Business Legal World. We welcome you, ma'am. Over to Priyanka.
May I now invite Mahalakshmi Pavni ma'am, Senior Advocate, to give her welcome speech.
Thank you, Priyanka. Thank you, Priyanka. A very good evening, ladies and gentlemen. I'm delighted that today we have with us, amongst us, one of the most composed and eloquent speakers for today's webinar. And she is none other than Miss Madhavi Divan, who is my dear friend. I must also let you know, friends, that Miss Madhavi Divan was on the panel assisting the Learned Advocate General for India in this case called Shaira Banu versus Union of India. This Shaira Banu's case is one of the most popular cases known as the Triple Talaq case. In fact, there have been numerous religious practices in India, and India has been a melting pot for cultural traditions and religious practices. But what is said is these practices are totally unfashionable, outdated, but they still remain to be professed and practiced in the name of culture. So, and these modern times, it's actually the world has become such a smaller place thanks to technology, and in the age of information engulfing the whole world, we have a lot of exposure to the internet, and the world comes to us into our drawing rooms at the click of a mouse. So because of which our perceptions this has enabled us to view our societal norms, cultural and traditional practices with greater objectivity and induce some introspection as to whether these categories of practices prima facie appear discriminatory, are tenable in synchronization with our constitutional scheme. Are these cultural, religious, traditional practices such as triple talaq or polygamy or female genital mutilation violate ruthless fundamental values and our right to life, right to live with dignity, on which the superstructure of our constitution stands in the society, and these traditions and practices are a black spot on our constitution. Well, I don't want to take much of your time right now, but I would like to welcome Madhavi, who is our keynote speaker today. But before I go on to invite Madhavi, I must tell you that Ms. Maharavi Shren, she is our speaker, a young, dynamic, and very energetic member of the Supreme Court Women Lawyers Association, who will introduce the topic, subject about triple talaq. And my dear friend Madhavi, she will give her experiences about the subject, how she assisted the Learned Attorney General, and she has her experiences, this cause to women for a larger cause. And I would also want to tell Madhavi on a lighter note that she's a very admired woman. You know, Madhavi, fans, you had two fans in my house. My father-in-law is no more there. Said that one advocate who argues so placidly, so calmly, without losing her composure. And he, in fact, asked me to imbibe from you. Madhavi, and I must tell you, the next ardent fan of yours in my house is myself. Sadly, this adage is so true. Ghar ki murgi dal barabar. I have no value. Madhavi, this is your stage, and you rock. You are an inspiration to many, Madhavi. I just hope, and I now call upon Madhavi to please speak about the subject. Thank you.
Good evening, everyone. Thank you so much for giving me this opportunity to speak on this topic. We have a wonderful guest here who's going to discuss the topic in detail. I'm just giving a very short brief about the topic. We know that the law with regards to Hindu law, with regards to Hindu divorces, it is so popular that everybody knows how to approach a court, what are the rights of a woman, of a Hindu woman or a person not belonging to a Muslim community. But so far as Muslim divorce is concerned, it is somewhat uncodified, or it is something which is not as popular as Hindu divorce. So the reason for bringing this topic today was so that it could be brought before our listeners, our participants here, and generally women regarding the topic. The discussion today is going to primarily revolve around divorce under Muslim law, giving a deep analysis to the Triple T judgment, which was passed by the Honorable Supreme Court of India, and the developments which have happened post the judgment, that is the Muslim Women Protection of Rights on Marriage Act 2019, which came into existence by 2019. Further, the procedure that is... Am I audible to everyone? Am I audible?
There's a lot of disturbance, Mahi.
Yeah, I could feel that. I believe somebody is not on mute.
All non-speakers should put off mic so that we can hear the speaker, Maharavish.
वो तो जब शेयर करते तो वो कर रहा था ना, शेयर में तो नहीं आएगा ना, शेयर में तो ऑडियो नहीं आएगा.
Bhakti ma'am, may I request you to please mute everybody?
उसमें तो आ ही नहीं, उसमें तो वीडियो भी नहीं आ रहा.
Veena ji, please mute yourself.
आप लगा के देखो.
Veena ji, please mute yourself. All other participants are please requested to mute yourself so that the speaker could be heard clearly.
861 8106.
Coming back to the topic.
0927.
Am I audible to everyone?
Yes, you are audible now.
Further, the procedure of acquiring legal divorce under the Muslim law as it stands, that is what we will be concentrating today on discussing in today's topic. There are certain provisions with regards to mandatory maintenance under the Muslim law. We will be giving a light introduction to that as well, bringing some light on that also. So far as getting a divorce via court and getting a divorce through TALAQ, the procedure which is under the Islam. So we will be discussing these two types of divorces here. For further more queries, if anybody has, I request you to please collect all your questions together And after our keynote speaker is done with the topic, she'll be taking up your questions. So please feel free to speak only at that time. Until then, may I please request everyone to please be on mute, and may I request Madhavi ma'am to please take over and enlighten us with the topic today.
Madhavi ma'am, please unmute yourself. Yeah.
Yes. Right. Can you see me? Can you hear me?
Very clearly.
Reasonably well?
Very well.
All right. Just give me a moment. Right. So thank you very, very much for inviting me. And I have to say that it's a great pleasure after so long to see you face to face, even though it's virtually, but something is better than nothing, because it's been many months since I've had the opportunity to meet you or greet you in the corridors or in the ladies' room. Life doesn't feel the same anymore. So thank you very much, Mahalakshmi, for that very, very warm and flattering welcome. Priyanka, Prerna, Bhakti, Mehravish, Mansa, Shubhra, Sudha, and the entire executive body of the organization. It's really, speaking of triple talaq, when you asked me to speak on this subject, I realized that nearly 3 years have gone by since the judgment in Shaira Bano came. And it's amazing how time flies, because the judgment was delivered. I remember the day still. It was 22nd August of 2017. And the matter had, of course, been heard before that in the summer vacation of 2017. And we had gathered in the courtroom that morning, in courtroom number 1, which was, of course, packed with advocates, all in anxious anticipation of what the outcome was going to be. And we really didn't know which way the verdict was going to swing. And it was a very packed courtroom. Everyone was sort of jostling to get in the front, and the atmosphere was one of, of suspense. So for me, in my mind, I had something to do with, as Mahalakshmi pointed out, I had assisted the Attorney General at the time, Mr. Rothke. And it was an exciting time. Of course, I have to confess that I hadn't been a family lawyer or a divorce lawyer, other than a few cases here and there. Essentially, my original training was in commercial law, and then I, of course, diversified into other things. So it's not as if, one was an expert on this particular branch of law. But so we had churned out this affidavit, which was the government's response after a few days very, very, very solid research. But the hearing was over. It lasted all of 7 days, which I think was a pretty short time for a case as contentious as this one. But we still didn't know which way the matter was going to go. So I remember there was a lady advocate standing next to me morning, and I asked her, I said, what do you think? And she said, I don't think you're going to get a verdict in, the petitioner's favor, because these are status quos which are very, very difficult to change. And, for the first time, I felt that even though something was so inherently unequal and discriminatory, we may just not succeed. And I realized that it is very, very difficult to change a status quo. So that morning, when the bench assembled and Chief Justice Keher began to read his judgment, and soon, the worst fears were kind of being confirmed, because he had actually rejected the petitioner's petition, Shaira Bano's petition, and he held that the practice of talaq-e-bidat, or instantaneous triple talaq, was an essential practice of Islam. One could sense that, you could feel that sense of disbelief in court. And it was very, very disappointing. And at the time, we had no clue that there were going to be other judgments also delivered by the court, because there was no indication on the cause list that day. And so we thought that this is it. And I remember there were some, senior advocates also who rushed out of court immediately and addressed the media. And the first flashes of news on the TV channels were that, triple talaq has been upheld as a practice, as an essential practice of Islam. And then, of course, Justice Kurian Joseph took over and he began to read his judgment. And then we felt maybe it's, there is a glimmer of hope. Maybe this is not over after all. And he held that this is a practice which is not recognized under personal law at all. He said that this is bad in theology and therefore bad in law. What is bad in theology cannot be good in law. But he was speaking, of course, for himself. And then, of course, we had Justice Nariman, who said that he struck it down on the ground that it was a manifestly arbitrary practice which violated Article 14 of the Constitution, and he struck it down on that ground. And of course, at the very end, he added that Justice Lalit concurs with me. And it was only at that point that we really knew what the final outcome of the case was, that it was a 3:2 majority. But it was so contentious that the very next day, there was an application, there was a mentioning on behalf of the All India Muslim Personal Law Board, who had argued on the other side. And the application was that, look, please declare that the majority is in our favor and not otherwise. And of course, the Chief Justice just sort of summarily dismissed the application, saying, we've said what we had to, and that's it. So, for me, I think it was a very personally a chastening kind of experience, because you realize that even sometimes when something looks so obviously discriminatory, so obviously gender unjust, it's still very, very difficult to change a status quo. Now, of course, this was a judgment which made waves across India and even overseas. This is something which is still being talked about. I had the opportunity to attend on behalf of the government a conference. It was hosted in Malaysia, and there was representation from women all across, not just the Indian subcontinent, which is Pakistan, Bangladesh, Sri Lanka, but also some other countries, including Malaysia, Indonesia, and so on, with very substantial Muslim populations. And this verdict was still being talked about. This is late last year. Really hailed as a path breaker for gender justice and gender equality among Muslim women. Now, but what is really interesting is that a judgment which is hailed, and it is historic, there is no doubt about that, because it's a leap forward, it's a leap of faith. But nonetheless, when you do read the fine print, you realize that this judgment really doesn't say very much about gender rights and gender equality. So it's interesting because the two opinions which form the majority, that is Justice Nariman's opinion and that authored by Justice Kurian Joseph, they take two very different routes to arrive at the same destination. So Justice Kurian Joseph, what he holds is that he looks at it from the perspective of irreligiosity. And what he says, sorry, am I audible? Right. What he says is that, look, the question he poses is that what is...
Yes, ma'am, carry on.
Yeah, what is Quranically wrong, could it ever be legally right? And he says, no, it cannot. And that is how he comes to that conclusion. He holds that, look, among the Muslim community also, there is by and large consensus that this is a sinful practice, and therefore what is sinful surely cannot be good in law. What is bad in theology has to be bad in law. And that is news. It was reported even in the Time magazine. On the other hand, what Justice Nariman also holds, I've already told you that he describes it as manifestly arbitrary. But both the judgments, what they do is to look at it from the standpoint of the matrimonial bond and how important it is in the faith to preserve matrimony, to preserve marriage, the institution of marriage, which is the foundation of family life. And so what they really do is the lens is really the marriage. and not so much discrimination. And what Justice Nariman says is that, this is such a whimsical and capricious practice. It doesn't give any scope for a reconciliation as is provided in the Quran and other texts. And therefore, he says that this is absolutely unsustainable. And therefore, he looks at it from the prism of the marriage and preserving marriage. And on discrimination, he very candidly says that, look, I am striking out this practice on a narrower ground, which is of manifest arbitrariness. So we don't need to go into this aspect of discrimination. So therefore, it is looked at really within the contours of the faith and what the learned judges felt the faith was really what the scriptures, the sacred scriptures were saying. So it was really a judgment which was very much within the bounds of faith. It wasn't striking down something which they said that the faith was actually sanctioning. Now, I've often wondered why they didn't get into the argument of gender discrimination, because that was really what the case, in my view, was about. And that is what the petitioners argued. That is what the women's organizations who were intervening argued. And that is what the government of India also argued. So my conjecture is, of course, that, the moment they upheld it, or the moment they upheld the gender equal status of women, it would mean that several other gender unequal practices, which include, for example, polygamy or nikah halala, or there might be other practices in other faiths as well, would automatically become vulnerable. And the court, being, of course, this was a case concerning a minority community, perhaps the court wanted to, tread a little gingerly, a little gently, and therefore they chose this one practice, that is instantaneous triple talaq, and this being the kind of the lowest hanging fruit, they locked it off on a limited ground. But what is also interesting, and some of you might know, that the Shaira Banu petition was really about a challenge to 3 separate practices. It was not about talaq-e-bidat or instantaneous triple talaq alone. It was also challenging polygamy, also challenging nikah halala. But when the bench assembled in that summer vacation of 2017, they very candidly, the first thing they said was that, look, we are going to limit this hearing only to triple talaq, that is talaq-e-bidat. We are not going into the other issues. That will be decided some other time. So as a result, those other 2 issues are still pending. Now, there are a couple of other interesting points that I'd like to make on this issue. One is the judgment of Narasu Appa Mali. Now, some of you may be aware of this judgment. It's a 1951 judgment of the Bombay High Court, a division bench of the Bombay High Court, comprising a very formidable combination of Justice M.C. Chagla and Justice Gajendra Gadkar. Now, this is important because this was a case which both government and the petitioners were saying in the triple talaq case that please reconsider this case and overrule it, because it's high time. This has become a barrier to questioning personal law and it should be done away with. Now, what did this judgment Narasu Appa Mali say? What it said very simply was, and this was actually a passing observation, what it said was that personal law is not law within the meaning of Article 13 of the Constitution, and therefore it cannot be tested on the anvil of fundamental rights. So this was an interesting case, Narasu Appa Mali, where a Hindu was challenging, this is way back in the early 50s, he was challenging the law prohibiting bigamous marriages among Hindus. And one of the arguments which he raised was that, look, this is utterly discriminatory, because what you are doing over here is that you are preventing a Hindu man from marrying a second time or a third time, whereas you are permitting Muslim men to do the same thing. Now, the court summarily rejected this argument, saying that that's ridiculous because, reform can come to any community first in point of time. It's not necessary that reform has to come to every community simultaneously, and merely because it comes to Hindus first doesn't make it discriminatory. And in that process, what they held was, it was a passing observation, as I said, that personal law is not to be tested on the touchstone of fundamental rights. But this, this observation really, what I feel is that it carried really disproportionate so many judgments, even of the Supreme Court, rely on this judgment not to go into, to kind of steer clear of challenges of very unequal practices like triple talaq, like polygamy in the past. And there are several judgments where Narasu Appa Mali is relied upon to just skirt those issues. So what Narasu Appa did was to elevate this whole notion of personal law into a sort of an impregnable fortress where nobody could enter. And so what happened in practice over the years, what we've seen is that there was legislative reluctance to make reforms sometimes because religious sensitivities are often involved. And at the same time, the courts would also be reluctant to enter. So the legislative reluctance was compounded by judicial reluctance, and therefore there was a stalemate and a status quo sort of continued. So I would say that Narasu Appa Mali is something which must be reconsidered. It was not that the court did not think it fit to go to revisit it in the Shaira Banu case, but later in the Sabrimala case, there is a passage by Justice Chandrachud where he says that in an appropriate case, the ghost of Narasu Appa Mali must be revisited and in effect exorcised. The other point that I would like to make here is a test that was applied in that case and in several other cases. And again, it's a test which needs to be reconsidered. And that is the essential practice test, which is still good law, but is going to be revisited in the sequel to the Sabrimala case. Now, the essential practice test, in effect, you know what it is, which is that the court goes into the issue of what is the core of the religion. The core of the religion is what gets protection under Article 25, but then there are other practices around it, which according to the court may be quote unquote inessential practices. And these are practices that can be tested and gone into and struck out if the court finds it violative of fundamental rights. Now, this is very problematic in my view. And although I have to say that we applied it in the triple talaq case, it has been applied in several cases even subsequently because it is still good law. But it certainly needs a revisit because I would say it's fundamentally problematic that secular courts where judges have secular training should be able to have to go into these issues, very complicated issues of religion on which they may have no expertise. So religious interpretation naturally is best left to theological experts. It's very difficult for the court to sift out the grain from the chaff and tell us what the core of the religion is and what the inessential practice is. And so that exercise is to be best kept out of. Of course, the courts must apply fundamental rights, and where they find that a practice is, it violates fundamental rights in a very real and substantial way, then it must intervene. And it doesn't need the essential practices test to have to do that. Now, talking of what happened after the triple talaq judgment, as you know, it became a penal offense. That new law, of course, there's been a lot of debate both before it was passed and after as well. And there were 3 or 4 main points which were raised in opposition to the bill and then what became the law. And I'd like to briefly discuss these points with you. one of the points raised was, since triple talaq or talaq-e-biddat is already de-recognized and rendered void by the court in Shaira Banu, why do you need to criminalize a practice which is already invalid? That was one of the questions. Second issue was, marriage is a civil contract under Islamic law. So why criminalize something which is in the realm of... Third is, how will the man provide for his wife and children if he is to be incarcerated on account of the statute? Now, just to try and answer some of these questions, because I did think about it and I came to the conclusion that yes, we do need a penal offense, and there are many reasons for it. Because the court has, of course, declared the law and said that this is an invalid practice, it's struck down. But the point is, what does a woman do when she finds that she encounters such a situation where her husband, despite the law being declared by the Supreme Court, still issues a triple talaq? Now, where does she go? How does she enforce the judgment? Because she may say, look, the Supreme Court has said that, you know, triple talaq is invalid, but the court, but the husband said, too bad. I mean, you know, you're out of here, the marriage is over. So how does she enforce it? So you do need a law for that, one. Secondly, the question about marriage being a civil contract in Islam, of course it is. But now that the court has declared that this is not within the realm at all of divorce, that a marriage can never be put an end to by the method of triple talaq, that means it falls outside. It has been thrown outside the realm of that civil contract. It cannot terminate anymore that civil contract. It's no longer part, that form of divorce is no longer recognized in the realm of that civil contract. Then you can penalize it, you can criminalize it. The third is, of course, and perhaps the most important, why should it be a criminal offense in that sense? What is a criminal offense? How is it different from a civil wrong? And here I'd say that when we look at the commentaries of Blackstone on what is a public wrong and how is it different from, how is a criminal wrong different from a civil wrong? And what he says is that a criminal offense is essentially a public wrong. It's a wrong against the public. There is a societal interest involved there. And to protect that, there is a criminalization. There is a penal offense on that count. Now, we find that there are several civil wrongs. The civil wrong is, of course, between two individuals. And there are many civil wrongs between individuals which may still be tantamount to a criminal offense. There may be an overlap. Like, for example, the law of defamation. It's a civil wrong, it's a tort, but it is also a criminal offense because under the law, we regard reputation, an individual's reputation as something so vital. If there is such an important societal value in reputation that the law thinks it fit to criminalize it. So the same act can be both a civil wrong and a criminal offense. Now, in the case of triple talaq, you know, I'll give you two examples. One is, of course, something like, say, dowry. Dowry is also within the realm of you know, the marriage, in the sense that, you know, there will be people who will tell you that the origin of dowry was, you know, stridhan, or you know, because the woman was not going to inherit, and therefore this was a gift at the time of her marriage. And therefore, you know, a lot of people believe that it's a perfectly legitimate thing. But now what do you do when there is such an oppressive, you know, pernicious practice which pervades society, where there are extortionist demands, there is violence that accompanies dowry demands, etc., etc. And therefore, society thinks it fit to criminalize an offense and the act of demanding dowry, because it is there is a message that you want to send out of zero tolerance against something which is such a pernicious practice and which violates the social status of a woman. Now, if we look at, for example, the law on bigamy under the Indian Penal Code. And again, there too, a similar argument may be raised that, look, just as in triple talaq, you say that the divorce is invalid anyway, so why criminalize it? In the case of bigamy, the second marriage, the so-called second marriage, is also invalid. But why do we criminalize it? We criminalize it because we think that this is something which is so harmful as a societal value. We do not want to encourage bigamy. We want to send out a message of zero tolerance towards such to acts of bigamy, and therefore we criminalize it. And there too, the man is required to provide maintenance for his wife and children even from the first marriage. So if he is incarcerated, the same argument can be made that, look, how will he provide if he's going to be in jail? And similar argument was made when triple talaq was being criminalized. But the point is, when we want to send out a message, and a strong message, that this is something that will not be tolerated, this is something that affects the social status of women, you criminalize. And the idea is not to start putting people in jail. I think that is one thing we need to remember. The idea is deterrence. The idea is to send out that message. And in the triple talaq case, I'll tell you this, that when you read some of the passages, and it's worth reading some of the passages from the affidavit of the All India Muslim Personal Board, you will realize why a strong message needs to go out. And, some of the things they said, I could actually read from them. What they say is that, look, if you put an end to practices like this, that is an easy way out of a marriage when a man is unhappy with his wife, then he may actually resort to murdering his wife or setting her on fire in the dark of night. And therefore you cannot do away with such a practice. You must give him a way out. And sometimes, well, it is the woman herself who says, give me triple talaq and let me go. So, these were the kinds of responses, and the sheer vehemence with which the abrogation of triple talaq was opposed also tells you that, there is such a strong patriarchy at play, and strong, very strong forces at play, that you feel that, no, if you want to send out a message of zero tolerance, something like that, certainly a practice like that needs to be penalized. Now, the point I made earlier, the idea of deterrence. Now, one of the points which were also being made when the bill was being debated was that, there are hardly any cases of triple talaq. So why this disproportionate emphasis on this issue, and why do you want to criminalize? And the answer to that is that, look, one is, of course, I think this is a misnomer that it's not prevalent. I think it is very much prevalent. And at the stage of the arguments before the Supreme Court, I remember we had relied on the NCW report at the time. This was an older report, but at that time there was Mrs. Saida Hamid, who had, she was heading the NCW at that time, and they had got this report after compiling information from women received, complaints were received from the length and breadth of the country. They went and interviewed people, and they found that, look, women complained bitterly of polygamy, of nikah halala, as well as triple talaq. So it's not correct to say that these cases are, very minuscule. It's not that way. But let us assume that, even if the numbers are small, the point remains that it is not so much about the actual issuance of triple talaq, but the fear of it that dangles over a woman's head, because she knows that if she doesn't pander to her husband, if she doesn't sort of, dance to his whims and fancies, she knows the possible consequences. And so therefore, triple talaq is not about the actual issuance, but the fear that this may happen to her if she does not, toe his Lakshman Rekha. And this is something very important because it's very determinative of the social status of a woman, because it determines what she will do and what she can do within the confines of her marriage, within the confines of her home, and also her options and her choices outside her home. So for example, how much to be educated, what sort of career to choose for herself, is she going to be allowed to go out and work, etc. What is even her autonomy within the home? All of that is tied up to her social status. And if there is a sword like this dangling over the head, and if the husband has the power to turn her out or end the marriage in a flash of a few seconds, then I think this is something very, very serious. So therefore, there has to be that deterrence that, look, you cannot you cannot end a marriage in a flash of a few seconds like that. You do not have that unilateral right. And therefore, I think there is, in my view, justification for penalization and criminalization. And the idea is not to put people in jail. I can take about 5 more minutes. Is that all right?
Yes, ma'am, you can take.
Yeah, sure. Okay, so I'd like to mention a couple of things. There were 2 acts which go back to the 1930s, and it's quite interesting how, when times change, the whole paradigm changes. So this is, of course, we're now talking pre-independence India, and in 1937 we got the Sharia Application Act. So it's very interesting, because this is the very act, and section 2 is what Justice Nariman strikes down in his judgment in Shaira Bano, to the extent that it recognizes the practice of talaq-e-bidat, or instantaneous triple talaq. Now, this very act of 1937 came at a time when Muslim women in India, that was United India, pre-independence India, Muslim women were clamoring for better rights, and they were really pushing the envelope. So in the 1920s, in fact, both Hindu and Muslim women were really campaigning for better rights. And as you know, at the time, Hindu women had were perhaps much worse off than Muslim women, because they didn't have the right to divorce, they didn't have the right to inherit, all of that. So, they made a united effort. And at some stage, the Muslim women realized that, look, the Sharia is actually much fairer to us when it comes to inheritance compared to what the customary law was giving them. And a lot of these families, and I thought this was a very interesting insight which I gained, and I thought I'd share it with you. At that time, a lot of those families, particularly in Punjab, were the Muslim families were converts from Hinduism, but they clung on to the customary law when it came to inheritance, because it suited them. Because under the customary law, they did not need to give the women anything in inheritance. The women could not inherit any of the agricultural lands. But when it came to a marriage and divorce, they wanted to stick to the religious laws, the Sharia. So eventually, in 1937, when the Sharia Application Act came, it was actually regarded as very, very progressive for women at the time. So it gave them rights under the Sharia, rights of inheritance, which were simply not available to them under their customary law. So it was interesting. So at the time, the women actually preferred religious patriarchy over customary patriarchy. And I thought this was an interesting historical perspective. Now, in 1939, 2 years after that, there came another act, which was on dissolution of marriages. And what happened under that act was also a step forward for Muslim women. Again, we are talking of pre-independence India. And at that time, mind you, Hindu men or women didn't have the right to divorce, because as you know, traditionally under Hindu law, marriage is an indissoluble sacrament. You couldn't get a divorce till the reform, of course, came later. Now, under this 1937 Dissolution of Marriages Act, what happened was that the women who, they wanted divorce, they wanted out of a marriage, but the husband was simply not willing to give them khula or, negotiate a divorce. So this act of 1939 gave a Muslim woman the right to go to a secular court of law and seek divorce, a decree of divorce on certain specified grounds like cruelty or desertion or several other grounds. But these grounds, interestingly, are not so dissimilar to what later became available to Hindu men and women under the 1955 the Hindu Marriage Act. But so the right given to a Muslim woman to divorce on certain specified grounds, to seek that divorce in a court of law, was available to them in 1939. But when you look at, say, 80 years later or more, today, if a man wants to divorce his wife, he can, of course, talaq-e-bidat may be gone, but you still have talaq-e-ihsan, you have talaq-e-hasan, which are, of course, they are far more reasonable and they have a procedure for reconciliation, but they are still unilateral. It is the man who eventually calls the shots. There are other, for example, khula is available, but then the difficulty is what happens if the man does not agree. So it is still very unequal. And perhaps in pre-independence India, Muslim women made much better progress than they made afterwards. So I thought that was an interesting tidbit. And I think, I've said quite enough. I'll just conclude by saying that ultimately, it's often said that if you empower a man, you effectively empower him and him alone. But if you empower a woman, you empower her and you empower her family. And therefore, the implications of Shaira Bano transcend what is just, immediately obvious to us. It has, it's very intrinsically entwined with the social status of women. And, when women are able to help themselves, when they are able to be, sort of lift their status in society, there will be an immediate impact on their families, their children, and generally on the community. So, and it's important because women ultimately, it's not just about Muslim women. Women generally, we belong to every community, we belong to every caste, we belong to every religion, and we transcend all those very limiting barriers. We are half of the population. So when we talk about quota for this and quota for that, and I often wonder, of course, I'm not a great advocate for affirmative action in that sense, but no one thinks of us, at least enough, as half of the human race. So thank you very much. Thank you very much.
We will have a question answer session now. Madhavi ma'am, I have a question for you from Archana. She says, what was your most challenging moment when you argued triple talaq matter in Supreme Court?
Well, I have to say that I did not argue the matter. The matter was argued by the Attorney General, Mr. Mukul Rohatgi, on behalf of the government of India. I have to say that really the most challenging moment was anticipating the verdict, because everybody wanted to know from me, how do you think they are going to respond? And I had sort of indicated what I thought and my surmise. But when I heard the first judgment being pronounced by Justice Keher, I think I really had my heart in my mouth, with great shock and a sense of disbelief to start with. But fortunately, things turned very quickly. But no, I think it was a very it was a very enriching journey. I mean, and it was over about a year and a half, because I think it was in September the year before that we actually sat and prepared the reply. And my own take was that we should not get into the nitty-gritties of what the sacred scriptures say, because we are not experts, and a secular country, in any case, the state has no role to play in interpreting those scriptures. So I was of the view that we go on fundamental rights and gender justice, and we stay clear of that. And I'm glad that I got support in that.
Sudha Pal has a question. Sudha would like directly ask. She is treasurer of Supreme Court Women Lawyers Association. Sudha Pal, please.
Thank you, Bhakti. Thank you so much, my dear. Good evening, ma'am. Good evening, all of you. I am Sudha Pal, treasurer, Supreme Court Women Lawyers Association. Ma'am, I am asking only one question. Ma'am, hello. Ma'am, I am asking one question. What are your views about uniform civil code? Can you hear me, ma'am?
Yeah, you're audible, ma'am. She is asking, what are your views about uniform civil code?
Yeah, so you see, I think there's also a lot of misinformation about the idea of a uniform civil code. I think from my perspective, I would certainly say that, India is, of course, a country with phenomenal diversity, and we should preserve that diversity. However, at the same time, we have to have at least some common denominator of rights, because what can happen is, if one community is, say, there is reform, there is legal reform, and we've seen, I think when the Hindu reforms took place, and I think there are still steps we need to take, but still it was a big leap of faith when it happened. For example, divorce or even inheritance, and there were a lot of, naturally it was upsetting a status quo, and people felt that how do you our entire social structure is going to change, or the sons-in-law are going to run away with the property of the family, all of that. So it was disruptive. But the fact is, it took place at that time. And over time, I think women of the community were able to make use of what they got, because that also, it changed their social status. It's not just about the law. I think over time, it changed their status, and they were able to, reach out and really, in that sense, work what the Constitution gave them. And what happens is, if different communities, if you're too far apart, and I'm not talking of the difference in the culture that we must preserve, but if we are too far apart on rights, on basic rights which are available, like on marriage, divorce, adoption, inheritance, if we are too far apart, then over time you're going to find that communities are moving at a very different pace, and that is very problematic. And that is going to create divisions in society. It is going to create, and it has, we must accept that it's going to create divisions, or, whether you are represented in a particular force or you do not, how many women are in the workforce from a particular community. All this depends on how much, the social status of women. So if a woman is educated, if a woman has rights, if she's exposed to the workplace, naturally her child is going to, have that exposure. He's going to have better prospects, or she's going to have better prospects. So I think unless communities, at least on a certain denominator of rights, unless we move forward at a similar pace, it's going to be very problematic. So it's important to discuss what exactly we mean by the Uniform Civil Code. And I don't mean that we should sort of rush out all our differences, but certainly we need to come to some common platform and a common denominator of rights.
Well, Shubhra also has a question. Shubhra is Assistant Treasurer. Shubhra, please ask what you want to ask. Shubhra is sending me a request. She has a question. Admin, please unmute Shubhra. She wants to ask a question.
Good evening, Madhavi ma'am.
Hi.
Hi, ma'am. Thank you, ma'am. I am very much enriched from your elaborate and valuable discussion. When one Muslim lady lawyer from Kerala has moved before the Supreme Court of India on 6th July 2022 against the Muslim Women Protection of Rights on Marriage Act 2019. My question is, what are the questions
she has arisen on the provision over Triple Talaq Act.
I'm sorry, I didn't get your last sentence. She's challenged, is that the constitutional challenge?
My question is, what are the questions she has arisen on the provision over the Triple Talaq Act?
I'm sorry, I have not read that petition. I have not had the opportunity to read that petition. I don't know. But if there is a challenge, I think by and large is the grounds that I mentioned in my address, and that it is a civil contract, etc., and that you cannot criminalize. It's already been invalidated, etc. It doesn't amount to, it doesn't meet the tests of a criminal offense, etc. And who will?
And if I may add, the question that she has raised in the Kerala petition is just like 498A is being misused by women by saying that there has been cruelty against me. Similarly, is it not possible that the provisions of penalty may be, used in a bad manner?
Well, you know, misuse of the law is always something that we need to deal with. But that doesn't mean, I mean, if you ask me whether we should criminalize or we should decriminalize dowry demands, I would say no, we must continue to criminalize dowry demands. So you see, you know, let's remember one thing, that ultimately a woman also wants to save her family and her home and her children. So therefore, you know, this law also provides that it's only the woman herself or her blood relative who can file the complaint. It can also be compounded, right? So therefore, I think that has been taken care of. And I don't think that a woman herself would want to misuse that provision unless the husband has really tried to sort of, you know, end the marriage in that way or misuse. So,
Rudraksh Gupta wants to ask a question. He's sending me a message. Admin, please unmute Rudraksh Gupta.
Good evening, ma'am.
good evening.
Thank you for this opportunity, Mahalakshmi ma'am and Supreme Court Women Lawyers Association. And my question is as follows, ma'am. So there have been various questions that have been raised on this particular issue after the act was enacted. Now, Section 3 states that any pronouncement of talaq by a Muslim husband upon his wife, by words either spoken or written or in electronic form or in any other manner whatsoever, shall be void and illegal. While on the other hand, Section 5 says that there has to be a subsistence allowance that has to be paid by the husband while he is in jail to the lady whom he had pronounced the talaq upon. Now, there have been questions which have been raised upon the logic which has been applied while framing this law, stating that when a man is in jail, there will be a difficulty on part of him to pay a particular allowance that they're asking a man to pay. So what are your opinion on this, ma'am?
A man is, as I first of all, as I said, the idea is deterrence. The idea is that the man should never pronounce triple talaq. I don't think that the object behind the law is to send him to jail, right? So if he does not pronounce triple talaq, or having made that mistake, say in a drunken stupor or a fit of anger, if he does that, and if he apologizes, if the offense is compounded, which there is scope for, then I think everything is solved and they go back home at least reasonably happy. But even see, the responsibility to maintain the wife is his in law anyway. So even if this provision did not say so, you know, it is his duty to provide for his wife and children. Now, if you look at the bigamy law, similarly, the husband is under an obligation to provide for the first wife and her children, right? So now the same question may be asked that, look, the second marriage is so-called marriage is invalid anyway, and you're going to send him to jail. But why should, how will he, if he goes to jail, how will he provide for the children of his first wife and children? So I'm saying that, you know, we've got to look at the object and the spirit of the law. It is not to send men to jail. The idea is to ensure that you do not resort to such practices, and that there is a message of zero tolerance for such practices.
Thank you, ma'am.
Noor Jahanji has posted a question, and one question is there from Sonia also. They are asking, are there still any loose barrels which need to be fixed, even after this judgment?
Sorry,
Are there still any loose barrels? Are there certain things which are still required to be fixed?
Are
even
there other practices?
Yeah, regarding the practices and laws also.
I would say that frankly, TALAQ was, I mean, it's a historic step, but it is still a baby step. So, you know, if you look at even when I was studying TALAQ and Hassan, and of course they provide for, they are far more reasonable methods of divorce, but then they are unilateral. They are unilateral. Now, if you look, for example, at what happened in Pakistan and Bangladesh, of course, at that time they were one country, but there also, you know, the issue arose because there was a schism between the modernists and the traditionalists, and the traditionalist says that, look, you cannot meddle with the Sharia because this is ordained, divinely ordained. It is immutable, and you can't, nobody can meddle with it. And there, the modernists, however, and they prevailed. What they said is that, look, we have to use ijtihad, the principles of ijtihad, which actually, interestingly, you know, Allama Iqbal has always made a reference to ijtihad in a lot of his speeches and writings. And they said, use ijtihad, or that flexible interpretive intelligence, in order to interpret what the Sharia tells you. So, for example, the example that they gave, and I'm talking about 1950s Pakistan, the commission which gave that report and which led to their reform law. And they said that, for example, polygamy is permissible under the Quran, but you have to look at it in a context. And that, look, in several communities, not just Muslims, polygamy was permitted. It was permitted among Hindus also, and Christians also, and many other people. But the point is that Islam at that time put an end to, or put a limit to, the number of women you could marry. And you have to look at the historical context, which is that there were, because of the wars, the constant wars, there were a lot of women who were left widowed. There were children, and that is why people were encouraged to marry, to take on more wives. But this was the circumstance, and they use this example in Pakistan to say that, look, the circumstances of those times said that marry, because social justice required it at that time in the 7th, 8th century. But today, the social justice demands that you don't marry more than once. And therefore, there are serious restrictions on marrying again. So that's how they came around it. So there are, to answer your question, yes, we certainly need reform when it comes to, say, other forms of talaq. There has to be codification at some stage. And if you compare, say, the Dissolution Act of 1939 with today, what is available even 80 years later to Muslim men, I mean, there is a huge imbalance. There is a huge imbalance.
Thank you so much, ma'am. We will take one more last question. It's from Shweta Sinha. She is asking, although it's not related to the topic, but she is saying, ma'am, what are your suggestions for improvement of conditions of women lawyers? I think it's...
Are you talking of professional?
Yeah, professional. She is asking for a professional guidance.
Do you want to articulate your own question? Is there something?
Ma'am, I will read out her question. She says, what are the changes we need for improvement of women lawyers? This is the question which she has posted in chat box.
Well, I think associations like this are taking excellent initiative, and I congratulate them, and please continue all the good work. I'll tell you frankly, my own journey was believe it or not, it was a difficult one. And I think I had many advantages also. I must concede that. But mine was also a very uncertain and a rocky journey in professionally, I would say, because I always wanted to be an arguing counsel. In my own family, there was no lawyer before of course, I got married, but my husband and I never worked together. We always had, whatever, my practice might have been much less, but, it was still an independent practice. And I hit many hurdles on the way, but I think women, first of all, that's the lessons which I have taken away, and I can only share that with you. First of all, tenacity. You just got to hang in there. There is no choice. And you have to, don't allow, you will face setbacks, but if you hang in there, I think if you make it through those 10, 12 years, and you take yourself very seriously, and you project that seriousness, many gains. When the higher you go in the profession, there are fewer and fewer women there. And therefore, I have said this even in some interview not so long ago, that, for 20 years, I've been around for 25 years. And for the first 20 years, my gender was always a hurdle. For some obvious or not so obvious reason, it was always a hurdle. First impression was, oh, how long will she last? She's got little children. She won't last. She's coming for sort of kill time, and then, she'll fall off. But so that impression also in the minds of people, say 25 years ago, it didn't help me. Then they thought that, no, she's well taken care of. She doesn't need this income. Therefore, they didn't take me seriously. In some way or the other, you know how it happens, women are. But that was the first 20 years. And thereafter, you get more importance because of women. I will say that. Because there are just fewer women. And I think now more and more women, if you last out, the sky is your limit. I mean, a younger generation is going to do much better than, say, mine or, what has passed.
Absolutely, ma'am. I would now request Mansa Singh for vote of thanks.
Bhakti, can you hear me?
Yes, ma'am. I can hear you.
I just want to say something to Madhavi on. Madhavi, I just want to thank you for being here. And I would say, yes, you have suggested that Shaira Banu is a baby step. Yes, it is a baby step in the correct direction after Shami Mara's case, that is 2002. So nearly about 18 years ago. So probably maybe in another 2 decades, I hope this baby step will ensure that there is a uniform civil code for everyone, because I firmly believe that women of all religions should have the same law. And, there has to be gender parity, whether it is maintenance, whether it is divorce, whether it is inheritance or succession or adoption. I want this platform to be there, and maybe, yes, so long as religious practices are concerned, I'm not going to say anything. But so far as this could be brought in, I think it will be a complete change in this world. The world will look up to India as a super power. It's not just by sending rockets to the moon and things like that. India is a superpower, but India will be a super power only when it says that its women are empowered and they have gender parity and equal laws. And thank you, Madhavi. Thank you very much. My dear Assistant Secretary, Ms. Mansa Singh, will now say a formal vote of thanks. Thank you.
Thank you so much, Mahalakshmi.
Thank you, ma'am. A very good evening to all of you. I, Mansa Singh, advocate, take this opportunity on behalf of entire Executive Committee of Supreme Court Women Lawyers Association. I thank all of you for making this session so wonderful by participating in it. I thank our esteemed keynote speaker, Ms. Madhavi Divan, learned ASD of India, covering the subject comprehensively. Ma'am, you beautifully enlightened the judgment of Narsu Appa Mali, a very good judgment. I thank Ms. Mahalakshmi Pauni, Senior Advocate and President of Supreme Court Women Lawyers Association, for her inspiration and efforts. I also thank Ms. Madhavi Shrain, Member Executive, for her informative talk on various aspects of the divorce under Muslim law. I thank Ms. Bhakti Pasrija Sethi, Vice President, Ms. Priyanka Mathur, Vice President, Ms. Prerna Kumari, General Secretary, Ms. Sudha Pal, Treasurer, Ms. Subhra Saha, Assistant Treasurer of Supreme Court Women Lawyers Association, for working hard to make this webinar a great success. I again thank all of our esteemed audience for being with us, taking time out of their busy schedule on a Sunday. Good evening, ma'am.
Thank you so much. Thank you, all of you. And thank you for all your love and affection. And keep up the good work. Please keep up the good work. Great. Thank you, Mahalakshmi. Thank you, the entire panel.
Thank you so much, ma'am.
Thank you so much, ma'am.
Thank you so
Thank
much.
you, everyone.
Thank you. Thank you.
A small announcement before we leave. We'll be coming up with more webinars in the coming weeks. Time and date will be shared with you very shortly. So stay tuned on our and follow us on our Facebook website page.
Thank you, Mahi. Thank you very much.
Thank you, all of you. Thank you.
Thank you, everyone.
Thank you.
Bye.
Thank you for